All right, here to discuss in studio, we have the trial attorney, Mackenzie Joy Brennan. Nice to see you in person. Thanks for being with us. All right, so how does this psychologist move the ball at all, or at least how is the defense hoping that she influences the judge here?
Yeah, I think there's going to be some potentially rightful incredulity about how much abuse as a young person and trauma as a young person defrays any of the actions that this person has taken. And so I'm interested to hear what she says about how trauma can, for example, take away his consciousness of the fact that his family members are dead. Can that be fixed? Is it worth fixing? Should it affect punitive measures?
The range here for this judge is 15 to 40 years on the top count that he pleaded, the second-degree murder, but also then life in prison without parole was what the penalty would be, but 15 to 40 was the minimum. Where do you think a judge is going to land when not only do we have some really heinous facts, but the fact that he was 16 years old at the time?
Those are the two things I was thinking too. It's a really tricky circumstance, especially if you do buy what this trauma psychologist is saying and believe that he still is not working with the competence of somebody his age. That this might be something where he's kind of in arrested development at the age of 16. It's really hard to justify putting somebody away who suffers from things like that for the rest of their life. On the other hand, how do you live with what has happened to this family?
Yeah, tough one. Mackenzie, stand by. We're going to get to our break. When we come back, we're not only going to get you into more testimony in the killer uncle sentencing for Eric Sweeney, but we're also going to take you out to New York for this case.
Sean Diddy Combs facing years behind bars. Court TV's Kelly Craft joins us live. Boots on the ground there in front of that courthouse. That's a live picture. We'll take you there next. Welcome back to Court TV Live. I'm Matt Johnson in today for Ted Rowlands alongside Julia Jenae. Big day here. Before we get you back into court in New Hampshire, let's turn our attention to New York, where it's sentencing day for Sean Diddy Combs.
Yeah, the music mogul, he was convicted on prostitution-related charges while being acquitted of the most serious charges back at trial in July.
Now, no cameras allowed in that courtroom, that federal courtroom, but Court TV legal correspondent Kelly Craft standing by. She's in Lower Manhattan outside. You've been in that courtroom from time to time, especially during the trial. Set the scene, inside, outside. What's happening? What's the latest?
Well, hi there, Matt and Julia. Big day here in Lower Manhattan because Sean Diddy Combs is going to learn his punishment. This is punishment for the two crimes that he was convicted of. He was convicted of 2 counts of the transportation to engage in prostitution. So what has been taking place so far? So earlier, before we were inside that courthouse, Sean Diddy Combs making his way into the courtroom, wearing the traditional sweater with the shirt underneath like we saw throughout this entire trial. When he made his way into the courtroom, he waved to his family members. His young girls waved really rapidly back at him. They were so excited to see him. He hugged his defense counsel and shook many people's hands. And then the proceedings ended up beginning. They began about 10:20 a.m. Eastern time. And the judge gave some overarching remarks at the beginning in which he discussed different things. For instance, whether acquitted conduct would end up applying in this case. He said that it would. Talking about some other enhancements, victims, defense counsel, always busy here in New York City with the sirens. But he talked about the victims, meaning Cassie, Ventura, and Jane. Should they be referred to as victims? Defense counsel has said that they should not be referred to as victims. The judge disagreed with that, Matt and Julia. Also, coercion enhancement. The judge said that that should apply. Also, the organizer leader enhancement should be applicable because Sean Diddy Combs organized freak-offs. These are comments from the judge. After he made those comments, he then said what sentencing range he thinks is applicable in this case. And what did he say? He said anywhere from 70 to 87 months. So 7 years and a few months on the top end, and then on the lower end, at least 5 years and 8 months. Now, that doesn't mean that's going to be the sentence. That's what he says the sentencing guidelines would indicate. So he took a look at many of the sentencing guidelines, and that's what he ended up coming up with. What we do know is that Sean Diddy Combs plans to address Your Honor. He did submit a letter, and this goes over what he is going to say to the judge. We have some excerpts from that we can put up for you on the screen, in which he is talking about things like wanting to say that he has remorse for the situation. But after the judge talked about that letter and that submission that Sean Diddy Combs made, and prior to him making his remarks today, this is what the judge had to say. He said that while Sean Diddy Combs has expressed remorse for some things, he has not expressed remorse for all. The argument that this was adults paying for time, not sex, is not supported by the evidence. So, strong words from the judge to Sean Diddy Combs. Again, we have not heard Sean Combs speak yet. What's taking place right now, the prosecution has completed their argument. They do have an opportunity to say more after defense counsel completes its argument. But right now we're hearing from one of Sean Combs' defense attorneys who's talking about Sean Combs' life, how he was the first, if not one of the first, black musicians to start a black record label, and how he did that despite many, many challenges in front of him. Also talking about other mitigating factors that they think apply in this case, including his own domestic violence, that he was a victim of domestic violence, also that he was a drug addict at times in his life, how that should apply. This is according to defense counsel, who's making their argument as we speak.
Yeah, Kelly, a lot happening there, especially when we know the defense ahead of this. We can almost picture what's happening in that courtroom. They put out that 11-minute memorial video. That's what it seemed like, where it just looked at his entire life and all of the good that he's done. Tell me this, we got word from you and our Court TV team that's there inside of the courthouse that there was an accuser who was going to be speaking for the prosecution, but it sounds like that's not going to happen today.
It's not, Julia. So this is Mia. She planned to speak. She wanted to speak. The prosecution put forth a motion to the judge saying that she would like to speak at today's sentencing hearing. Now, she had submitted a letter as well explaining her situation. And we do have some excerpts from that letter that we can put up on the screen for everyone, and people can take a look and see what she has to say in that. I'm not going to go ahead and read it to you, but I will say this. She will not speak because she said now, according to the prosecution, that she is afraid to do so because of the bullying by defense counsel. And so defense counsel put forth its motion objecting to Mia speaking today. They were saying things like she is not a victim. The judge scolded defense counsel as the sentencing case got underway today. He scolded defense counsel, saying that the language in the motion that he put forth was inappropriate and never to do that again, because he was referring to it as, although he didn't use the word, he was going along with what the prosecutor said, saying that this was bullying to a victim that wanted to come forward and speak, who now is not going to speak, Julia. But we can tell you we will hear from some of Sean Diddy Combs' children. 2 of his 3 children are going to be speaking today.
Wow.
Kelly Craft,
huge development.
Thank you for that update. We know you're going to continue to keep us updated throughout the day on everything that happens there, so we'll let you go for now. We'll bring in our guest who's here in studio with us, trial attorney Mackenzie Joy Brennan. Mackenzie, a lot we just learned from Kelly Craft. What I want to hone in on, first of all, it doesn't sound like the judge already is very happy with the defense. It doesn't bode well for the music mogul. But she said that he was asked if acquitted conduct would come in. Sex trafficking we had here, the allegations of RICO charges he was acquitted of, but the judge saying it could come in to his decision making.
And that has been a big debate in the last few days. You know, what conduct could be considered? Can that affect the sentencing guidelines? And what acts can be counted in calculating that sentence? Is it every time any of the victims crossed a border, or is it just each victim for themselves? And it sounds like the judge went with that 5 to 7 year bracket, more or less, is going to use that one. And it also sounds like he does not appreciate any of the defense's characterizations of these acts, and that does make me think that he's going to allow things in, like domestic violence, which he also cited in the bail hearing.
Yeah, you know, and denied bail multiple times, denying this defense in a lot of their motions leading up to this moment, to your point. Defense looking for time served, basically, likely 14 months. Prosecutors want an average of 11 years, something like that. We'll find out later today. But what do you think celebrity plays in a role in a trial like this? Is he being made an example?
I mean, it's hard to say that when he was acquitted of the most serious charges, and being outside the courthouse, because I was there at certain points of the trial, and it was all support. I mean, I think the only decision maker who...
What do you mean it was only support at the courthouse?
A lot of yelling outside pro-Diddy. There
Supporters showing up.
Yes, it was very much pro-Diddy rather than anti-Diddy. There were altercations that broke out, mostly if people expressed an alternative opinion. So in that sense, if anything, I would think the jury could have been swayed in that direction. Obviously, the judge is pretty immune from that sort of factor. And I think that things like this PR video and even some of these courtroom displays, the judge probably is not going to take kindly to that, because it is a pretty transparent ploy, and it's honestly pretty consistent with abusers too.
There is a difference in how you approach a jury versus a judge. Do you think his team is handling that well? Clearly, their approach with the jury, where they said, look, they embraced domestic violence. They even embraced the video, which was shocking, but they told this jury, yes, he did terrible things, but it's not sex trafficking. The jury agreed with that. But here now, with the judge, they are seemingly having this similar glowing review of their client in front of the judge, and it doesn't seem to be going over well.
I agree, and I wonder who is calling the shots behind the scenes. This, to me, seems like something that these attorneys, who have been very strategic and very good at knowing their audience thus far, it doesn't really track with what they would recommend in this situation. In what we've seen so far of them, it does track with the ego of somebody who has been able to smile his way out of situations in the past, and maybe trying the same tactic now and pushing his team to follow.
And I remember that in pretrial hearings leading up to the trial, which took place a few months back, but I remember he was trying to get them to submit this, you know, request this. So he's been leading the charge the whole way. All right, we have to put a pin in the discussion right now, but we are going to keep you updated throughout the day there in Lower Manhattan. Coming up next, we're going to get you back to that sentencing hearing for that terrible case out of New Hampshire where 2 little babies were murdered along with their mother. We'll be right back. This is Court TV Live, your front row seat to justice.
4 dead students.
None of it seemed to make any sense.
He was evil.
What devastation.
All I can do is scream.
Victim to Verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Interview with a Killer. New season premieres Saturday, October 25th. Only on Court TV.
We have been watching together the sentencing hearing out of the state of New Hampshire for defendant Eric Sweeney.
Yeah, this is a tough one. This is one where back in August, the 19-year-old pleaded guilty in the shooting death of his sister-in-law, Cassandra Sweeney, and his nephews, Benjamin and Mason.
Back in 2022, Sweeney, who was just 16 years old at the time, took a handgun from his brother's safe and shot his brother's family to death. He faces life in prison with the possibility of parole, and there's a range there.
Let's head back into the courtroom now. We've been listening to a psychologist who's testifying for the defense.
It's talking about a review of risk and protective factors in a rural state.
Thank you very much. Your Honor, at this point, we're going to ask that the court certify Dr. Oyen as an expert in adolescent psychology.
Any objection? Dr. Oyen may give her opinions.
Thank you.
Absolutely.
Yes. So Dr. Oyen, we hear a lot about adolescent brain development. What is unique about the adolescent brain as opposed to the adult brain?
What is really important for us to think about with adolescent decision making is that it's often quite misunderstood by lay people, by our society. I think that oftentimes, and research has supported this, that people attribute decisions in adolescence being associated with them not understanding the risk associated with a decision, or maybe not taking the time to consider the danger of a situation. In fact, when they have looked at this, they found that adolescents actually do consider, and sometimes they almost over consider, the risk that is associated with some of those decisions. However, there is something else at play. And so they do tend to make some different decisions, but it's not necessarily because they don't understand the risk associated with some of their decisions. What is really happening is that there are different parts of their brain that are being activated when they are approaching decisions. And what they call this is the social emotional system that's being activated. So it's not necessarily that they don't understand that there's risk associated with decisions. It's simply that, they're activating what we call the limbic system. It's your emotional brain. And oftentimes that emotional brain can be influenced by a lot of things. And in particular, the amygdala. The amygdala is really the size of an almond. And that amygdala we call it the fear center. And what's really fascinating about adolescents is that oftentimes they are guided in their decisions by that fear center. And it's also not the best decision maker for us. Again, it tends to be that we're mostly guided then by some of our emotions, concerns about how we're going to be judged by other people. And that tends to be how decisions are approached by the adolescents. There are kind of three main hypotheses about what's going on. One of them is the dopamine receptor remodeling theory. This is simply put, this is an idea that dopamine tends to dip when you are approaching adolescence. How I like to describe dopamine is that it's that thing that you have inside of you that if you were to go to a casino, for example, and you hit the jackpot on the casino on one of the machines, and that feeling that you get, that reward center feeling, that's dopamine. And the theory is that there is less dopamine and there's a dip when it comes to your adolescent time. And all of us in our adolescent period are trying to get more dopamine. And how do we generally tend to get that in our adolescent time? We tend to get that from our peers, from that approval from peers. And we'll do lots of things to try to feel better. The second theory is called buffering capacity theory. This idea is truly that not only is it more challenging for you to, you have this dip in dopamine? Buffering capacity basically says that I need more hits, So if I were to compare it to the casino, it would be that I have to pull that trigger a lot more on the casino machines to try to get that feeling of dopamine. And so what does that mean? That means I need even more peer approval. I need even more access to those kinds of reward center, the reward seeking things before I would be able to feel the same kinds of things that I was feeling earlier in my life. And then the third thing, which is a really interesting area, I will tell you, it's becoming something that's really important to me as an expert in this area, is talking about hormones and the impact of hormones on the brain. There's some interesting things about the differences between men and women, in particular, looking at testosterone, the impact of testosterone on decision making. There's also some really emerging cool research coming out about ADHD and taking a look at when are the most susceptible times for you to be dysregulated and engaged in poorer executive functioning. They're actually finding it to be in your adolescent times. And then, unfortunately, this is my own age, but it's perimenopause times. And so we just know that there's some things going on with hormones. They're a little bit more challenging to measure. I do want you to know that because in peer-reviewed literature, we tend to measure hormones by the use of maybe a hair follicle or a blood test. And those things are just looking at hormones when it comes to point in time. And that doesn't necessarily take a look at long-term impact of hormones. The other thing, go ahead.
I was just going to ask, so, we've spoken about the adolescent range. What age range are we talking about?
Yeah, great question. I think historically, and if you would have asked me this in 2007, I would have told you approximately ages 12 to 18, because of the things that we're learning and because this is a topic that's really relevant in this day and age, they've really expanded the age to either to be 12 to 19. And in fact, for some courts and in some cases, they're actually saying 10 to 24. And that's particularly because there's a whole emerging base of literature that talks about emerging adults. And, you know, nothing magical happens when you turn 18. And so we know that in brain science that your prefrontal cortex in particular is still in development. And it's not fully developed until, some people like to fight about this, but it's generally agreed upon that it's either age 27 all the way to age 30. And so we know that that prefrontal cortex is still in development. And that's why they're really expanding the age ranges of what it means to be an adolescent.
You spoke a little bit earlier about the difference in sort of decision making between adolescents and adults. So can you explain that difference?
All right, hitting the pause button right there as we approach the top of the hour. Our thanks to Mackenzie Joy Brennan. Thanks for being with us in studio. We'll see you later today.
Thank you so much for having me.
And we are going to get you into more testimony that we've been watching from the killer uncle sentencing for Eric Sweeney. Stay with us. Signal. So I'm going to bring in who we have here in studio to keep talking about this case. Trial attorney Mackenzie Joy Brennan is here with us. Mackenzie, you live in New York. You were there during this trial. It was happening in your backyard, essentially. Thanks so much for being with us. I'm going to ask you the question that I was starting to ask Kelly. And it sounds like there's a different kind of balance in this sentencing. We heard a lot of evidence from the government during the guilt phase, and the defense didn't put on any evidence. Contrast that with now, we're hearing a lot of reports about defense witnesses, defense pleading with the court to spare Diddy from a prison sentence, and not a lot from the government. What do you think about that being an imbalance inside of this courtroom?
Yeah, I think that this mirrors a lot of what we've seen in this sentencing phase. The defense is really putting a lot of show on, but I don't think they're really knowing their audience when they're doing that, because the time to do the showy tears, character witnesses, etc., would have been in the phase where a jury was assessing, not this judge who's been very clear that he's not playing with emotions, that he's not convinced by the emotional displays, and really is not having any of the emotion. So who knows if it will move the needle? To me, it would make this seem a lot less ingenuous, because
and judges don't like that.
Exactly. So I don't think this will do them any favors. Obviously, for the family and whatnot, it is a real, genuine emotion that I'm sure they're expressing, but
absolutely,
it's not uncommon for an allegedly abusive father to have this kind of response from his family also. So yeah. I don't know how much it moves the needle.
And someone who's got all of this fame, all of this support from the public, even if not now, certainly during his career. I want to actually play part of that video, because you've heard Kelly say that it's already been played there inside of the courtroom. This is something that the PR team for Sean Diddy Combs they put out to the public, and they also played it inside of the courtroom as a presentation to the judge. Take a look.
What you've given to the world, I don't think you know, man.
When my baby cries.
You gotta give her a bottle then. Know that you mean something to people. Know that you mean something to people, like you live somewhere in people's heart. My nose fell off!
Mackenzie, we've talked about this. Completely unusual for us to see a defendant have this kind of a presentation for a judge. Perhaps a jury, it might sway them. I think even that's a stretch, but this is being shown to a judge. And I'll get your answer a little bit later about the speaking engagement. But what's your reaction to the video?
Yeah, I think the proper time for this would have been when the jury was in play. I think they also knew on the defense that even if they are involved in this decision, that it's not something that they could have opened the door to, because once they bring in character witnesses on the positive side, that also would have allowed for all sorts of negative character witnesses. So that was too risky for them. The judge knows that. And of course, I'm thinking, is this PR company that is tied to Combs any subsidiary of the company that he was just on trial for RICO for abusing its uses? And that's a weird comparison to beg the judge to draw, in addition to everything else.
It is. So let me, before we go to break, what's your prediction on what year this judge might get, and the speaking engagements? Is that going to sway the judge either way?
I'm going to say 5 to 7 is the bracket that we're looking at. Obviously, that's the time frame that the judge went with in terms of what sentencing bracket he'll be going with, and I don't think that he would have chosen that if he'd planned to deviate wildly on either side. So I think 5 to 7 years, anywhere in that range. The speaking engagements, boy, really bad call. I wonder if it's a hubris thing that he got off on these bigger charges and it's counting your chickens before you're sentenced.
Or positive thinking. Who knows? Mackenzie, stand by. We're going to get to this break. When we come back, we'll keep you updated on what happens there in New York, but we'll also go back to that New Hampshire sentencing that we are watching, the killer uncle trial for Eric Sweeney. Welcome back to Court TV Live. We're going to go back now to New Hampshire, a courtroom where we're following the teen who's being sentenced for the murders of his sister-in-law and his 2 young nephews. Eric Sweeney faces life with parole for each conviction of second-degree murder in the deaths of Cassandra Sweeney and her 2 sons. Sweeney pleaded guilty to the murders back in August. Let's head back into the courtroom now. Pick it up where we left off. A psychologist who analyzed Sweeney is on the stand, and they are now under cross-examination.
The defendant exhibits character pathology, right?
Exhibits features of it, yes.
An antisocial personality disorder is a personality disorder, right?
Yes.
It has an onset in adolescence or early adulthood and is stable over time, right?
Yes.
It's an enduring pattern of inner experience and behavior, right?
Correct.
And it's experience and behavior that deviates markedly from the expectations of the individual's culture, right?
Yes.
And it's pervasive and inflexible, right?
Yes.
And it can lead to distress or impairment, right?
Correct.
And antisocial personality disorder involves a pattern of disregard for or violation of the rights of others, right?
Correct.
Sitting here today, you cannot make any determination whether and to what extent this particular defendant will mature and rehabilitate over time, can you?
I can make no specific discernments about that. I mean, I think when I look at the information we have now, which I think was missing with his extensive efforts at treatment, there's more information now to understand how we might address his needs.
The past experience is that when probation ended for his prior victimization, his behavior worsened, and he ultimately murdered 3 people, right? That's the historical fact, what we know of the defendant, Mr.
That's correct.
Sweeney. As part of the assessment that you were hired to conduct, you spoke to the defendant about the crimes with which he was charged, right?
I did.
And he denied to you that he committed the murders, right?
He told me that he could not remember elements of it, but yes, he did deny committing the offenses.
And the defendant did not tell you that he could not remember what happened, right?
He told me what did happen, but there were spaces in which he did not recall.
Okay, so let's go back to your deposition. Page 67, counsel. I'm sorry, Judge.
Oh, yeah, no, you counsel can freely approach. I should.
Line 5. Question, at any point did he tell you he couldn't remember what happened? Answer, no.
That's correct. You're right. I misspoke. It's not that he didn't remember. His account of the story was not consistent with what the facts of the case.
Well, we will get to that. What he claimed to you was that he did not commit the murders,
Yes.
right?
Correct.
And he relayed to you that it made him feel mad and hurt his feelings that anyone would think that he committed the murders, right?
That's correct.
And not only did Mr. Sweeney, the defendant, deny to you committing the murders, he provided you with an account of what he was doing when he claimed somebody else was committing the murders, right?
Yes.
Yes?
Yes.
He provided you with details in support of his claim of innocence to you, right?
Yes.
For example, he claimed to you that he was downstairs in the basement when he heard gunshots upstairs, right?
Yes, he did.
And he claimed to you that he felt frightened when he heard the gunshots upstairs while he was in the basement.
That's correct.
And he further claimed to you that ultimately he went upstairs and he discovered the victims' bodies, right?
That's correct.
And he further claimed to you that after discovering the bodies, he returned to the basement and hid for a while because he claimed he was frightened, right? And that's what the defendant claimed to you during your assessment of him, right?
Yes.
No further questions.
Further direct examination?
Briefly. Dr. Guidry, do you believe that Eric does have antisocial personality disorder?
I don't.
Why not?
I believe that, as I mentioned before, Your Honor, that the diagnosis of PTSD better explains his issues.
I think you wrote one.
And to add, there's antisocial behavior, and then there's a pattern, a long-standing pattern. And what I have observed in the records with Eric, both is that he has these behaviors that we've talked about before, are emerged from the perception of threat, that are illegal, that are stealing and things like that. But he has also demonstrated at different times the capacity to care about others, to engage in treatment, to desire to be liked, and has not every moment of his life has been antisocial. Those features, to me, are more representative of this early impact on his life and the way he learned to navigate the world. So there's behaviors, and I see more behaviors than I do see that as character pathology in a persistent way.
And do you have any idea why he might be untruthful about what happened with the murders?
Well, we go back to in his testing for PTSD, one of the more elevated scales was defensive avoidance. And so this is sort of defending against anything that would indicate that you've done something bad or you've done something wrong, which, as I pointed out before, we all do that to kind of try and minimize it. We've made a mistake or done something bad, but at this level of extreme behavior, I believe that there's a part of his clinical picture includes this defensive avoidance pattern where he's cut himself off from taking responsibility for it because he can't. He's a fragile ego structure based on these earlier experiences. And we defend because we can't tolerate the negative feelings, the grief, the rage, all those things. And so that's why a person would be defended against the response the way Eric has been.
Have you, in your experience speaking with people who have committed murder, have you seen this before, that people do not remember or incorrectly remember the crimes with which they are charged? Or
Yes, I
have
have
convicted?
seen before, yes.
And do they ever later come to acknowledge what it is that they've done?
Some, not all, but some have, and it's often been seen where an individual, over time and maturation and some level of recovery, and when they can establish the capacities to tolerate what they've done, may get some recollection of the memory.
Thank you.
Any further cross-examination?
No, thank you, Judge.
Thank you, Doctor. You're excused.
All right, the second psychologist on the stand for the defense, wrapping up her testimony and trying to explain away why this defendant would have pointed the finger at someone else, saying they came inside and killed his brother's family. When we come back, we're going to hear the closing arguments in front of this judge as his defense tries to save his life and the prosecution tries to say that he needs a stiff amount of time behind bars.
My two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dan Marcel ever walked on.
it's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands. New episodes Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Welcome back to Court TV Live. We are going to get you back inside of that New Hampshire courtroom in just a moment. But first, we have this update out of the Widow's Words murder trial that happened in Iowa. And this co-defendant, a judge has just sentenced him, convicted murderer Houston Danker, to life in prison without the possibility of parole. Earlier this year, Danker pleaded guilty to murder for the shooting death of Ryan Cooper, who died inside of his home sitting in his recliner, shot in the face. Ryan was the husband of Danker's lover, Karina Cooper. Prosecutors said the two conspired together to kill Ryan for the insurance money and to start a new life together, but that never happened. Before the judge handed down his sentence, the court heard victim impact statements from Ryan's sister, Michelle Wilson. Take a listen.
I don't know you. In fact, today is the first I've ever seen you. But what I know of you, you believed you could do anything and get away with it. I think you're a psychopath, just like your accomplice. You couldn't appreciate the life you had. You wanted someone else's. You wanted Ryan's life. You wanted Ryan's dream. Ryan was sentenced to death by this murderer. Those of us left on earth were sentenced to life without Ryan. There's no sentence for this murderer that will achieve justice here. But the sentence this murderer receives today will ensure that he will never live his dream or anyone else's dream for the rest of his pathetic life.
Houston Danker pleaded guilty after a jury found his co-defendant, Karina Cooper, guilty of murder. That happened earlier this year, and that trial played out here on Court TV. She is also serving a life sentence without parole. Let's turn our attention now, though, back to New Hampshire. We're watching a sentencing hearing there for defendant Eric Sweeney. He was 19 years old when he pleaded guilty back in August, but he was 16 when he shot to death his sister-in-law, Cassandra Sweeney, and his nephews, Benjamin and Mason. He is facing the possibility of his entire life behind bars. He took his handgun from the safe inside of his brother's house, and that's when he fired upon the entire family. He was living with them as they were his legal guardians because his mother wasn't able to take care of him. Let's go back into the courtroom now. We're going to listen to the defense's closing argument in front of this judge who is going to handle what should happen to Eric Sweeney.
The true design of punishment is to reform, not to exterminate mankind. That is what Part 1, Article 18 of the New Hampshire Constitution requires. A 35-year sentence, a 40-year sentence, and another 40-year sentence. 115 years total. That is a life sentence. The state is asking for Eric's life. The sentencing memos in this case have a lot of discussion about Miller and that line of Supreme Court cases. I promise I'm not going to go back through those, Your Honor.
I can assure counsel that I have reviewed the cases cited, both New Hampshire Supreme Court, U.S. Supreme Court, and cases from outside of New Hampshire as well, that both sides have cited.
Thank you. And it may be obvious from the court's knowledge from reading all of the sentencing memos and the cases that were cited in them, but I just want to make it clear that the state in this case is asking for the court to sentence Eric to a term of years that is the equivalent of a life without parole sentence. We are asking for a sentence of 40 years to life, concurrent across all 3 homicide convictions, and an additional suspended sentence, suspended for life. The state's sentencing memo consistently refers to the need to impose a significant sentence, and we do not disagree that a significant sentence is warranted in this case. But significant does not have to mean a life sentence. The sentence that we are proposing is also significant. And I think anyone that has ever stepped foot in a house of corrections or prison would know that 40 years is a very long time to serve a sentence. Miller says that children are different and must be sentenced differently than adults, and acknowledges that children's brains are still growing and maturing, and that courts must account for this in making sentencing decisions. For a sentence to be significant to a child defendant, it does not have to be a life sentence. The state spent some time in its memo of law, and I believe in its argument earlier today, discussing Jones v. Mississippi and its holding, the case that is the most recent in that line of Supreme Court cases. And I just wanted to note that in Jones, the court did write, "To be clear, our argument on the legal issue presented here should not be construed as agreement or disagreement with the sentence imposed against Jones. As this case again demonstrates, any homicide, and particularly a homicide committed by an individual under 18, is a horrific tragedy for all involved and for all affected. Determining the proper sentence in such a case raises profound questions of morality and social policy. The states, not the federal courts, make those broad moral and policy judgments in the first instance when enacting their sentencing laws. And state sentencing judges and juries then determine the proper sentence in individual cases in light of the facts and circumstances of the offense and the background of the offender." It is clear that New Hampshire courts have begun to speak on this very issue. As recently as July in State v. Tulloch, Judge McLeod of the Grafton County Superior Court held that the court determines that LWOP for minors is cruel because it effectively sentences a juvenile to death in prison, and the severity of the punishment increases with the youth of the defendant. Judge McLeod's decision, in light of greater protections afforded to people who commit crimes while they are under the age of 18 under the New Hampshire Constitution, determined that life without parole sentences are unconstitutional, whether mandatory or discretionary. They took it one step further than the Supreme Court line of cases. A sentence of 115 years is similarly unconstitutional. Even if 18 of those years were suspended as proposed, the sentence would be 97 years, with a potential release when Eric is 113 years old. A right to parole is meaningless when parole comes at age 113. This is a life sentence. It is cruel and it is unconstitutional. The reasoning in Tulloch is directly applicable to Eric's case and the specific sentence that the state proposes in this matter. The New Hampshire Supreme Court has acknowledged that de facto life sentences exist in two of the Miller resentencing cases, as the court is aware from the filings, Dingman and Lopez. Trial courts did an analysis of what a de facto life sentence, based on some Center for Disease Control tables, and the New Hampshire Supreme Court decided that respectively 45 and 50 years were not de facto based on those tables. The court declined to come up, though, with a bright line rule as to what a de facto life sentence was, but no court could reasonably say that a 115-year sentence or a 97-year sentence are not de facto life sentences. According to the tables, and
all right, before the defense makes their next point, I want to bring in trial attorney Mackenzie Joy Brennan, who is here in studio with us to help us understand some of these numbers that we're hearing. There is the option for parole under what the state is saying in this case, the prosecution, but the defense is saying basically what you're requesting from this court amounts to what we don't want, according to Supreme Court holdings, a 16-year-old, he was 16 at the time, getting life without parole. What do you think about what we're hearing?
Yeah, and I think the last comment that we heard about the de facto life sentence really clarified what the dispute is here. And obviously, yeah, if you're 16 and you're looking at 3 consecutive 40-year sentences, that is more than a life sentence. There's no scenario where that can be twisted into you living a life again. Now, who knows whether it sounds like New Hampshire does not have a bright line rule or a number of years that counts as a cutoff where it is unconstitutional after this point. And then you also have some interesting factors here. It's not just his youth, but there's also the potential personality disorder, and is that coextensive with psychological, with neurological allowances? Do we give it the same allowance when it's something like antisocial personality disorder, which is treated differently and manifests differently?
A lot of
All
trauma
questions.
here.
Yes.
According to the 2 psychologists that took the stand, the judge is going to have all of that to weigh. Do you think the judge is going to lean towards the far extreme here, or consider an option of parole? Because it doesn't mean you're out if you get parole in 40 years. It just means that the parole board now is going to get an opportunity to weigh in.
Yeah, you're right. I think that given that 40 years is still a pretty long time, it may not be a de facto life sentence. Frankly, it could be. Who knows? It's safe to err on that side rather than the really long sentence, especially given that it sounds like there is no precedent here. I doubt this judge wants to set a precedent in such a sensitive case.
A lot to argue here. Mackenzie Joy Brennan, thank you for being with us. Let's get to our break. When we come back, we'll have more Court TV coverage inside of courtrooms across the country next.